Hello, this clip is about the relationship between international and domestic law, and I will focus on the situation in the Netherlands, so the domestic legal order of the Netherlands. You can look at this relationship between the two legal orders from both perspectives. So let's begin with the perspective from the international legal order. Then the most important principle is that states cannot refer to the rules of their own laws as an excuse or justification for not complying with their obligations in the international legal order. And this principle you find in various guises in various documents and resolutions. For example, the Declaration on Rights and Duties of States, in the Vienna Convention on Law of Treaties, Article 27, and in the ILC articles on state responsibility. It's more tricky when we look at this relationship from the domestic perspective. So then the question is, how does international law penetrate, enter into the domestic legal order? It comes from far and it enters the domestic legal order. It's important at the outset to emphasize that the effect of international law in the domestic legal order is determined by each state's own constitutional law. So not by international law, but by the domestic constitutional law. And a state has a choice of two approaches, a monist or a dualist approach. So if a state chooses a monist approach, then international law is automatically incorporated into the domestic legal order. So it automatically becomes part of the domestic legal order. If a state adopts a dualist approach, then international law first needs to be transformed or transposed into domestic norms before it can be part of the domestic legal order. When we look at the effect of international law in the domestic legal order, there are three key issues that we have to distinguish. First, we look at to the validity or the applicability of international law in the domestic legal order. Second, we look at the invocability of international law in the domestic legal order, otherwise referred to as the direct effect of international provisions. And then finally we look at primacy or the supremacy of international law over domestic norms that conflict with these international norms in the domestic legal order. And so does international law prevail over domestic law, and under what conditions does it do so? It is again important to emphasize that the way these three issues are dealt with is entirely determined by the constitutional law of each and every state. So that is why I wanted to focus on one particular state, my own state, the Netherlands. And so let's first look at validity. This is easy. All international law in the Netherlands is valid, is applicable in the domestic legal order. Most of international law is applied indirectly, so indirect applicability, and this refers to a situation where domestic law is interpreted in conformity with the international obligations incumbent on the Netherlands. And so all domestic law has to be applied in such a way that it is in conformity with the Netherlands' international obligations. We call that indirect applicability of international law. Such applicability of international law cannot lead to a contra legem interpretation of the Dutch provision, which means that the Dutch provision would be applied in such a way that it directly contradicts the ordinary meaning of the provision. That would be going too far. All this is based on unwritten constitutional law of the Netherlands. So now look at direct effect or invocability of international law before the Dutch courts, for example. So here we have to look to Article 93 of the Dutch Constitution, which states that only provisions of treaties and decisions by international organizations which are binding on all persons by virtue of their contents can be invoked directly before the Dutch courts. So some of international law here is excluded. Customary international law is excluded. And only certain provisions that by virtue of their content can be invoked, can indeed be invoked. If we look to the third key issue, primacy, supremacy of international law in the domestic legal order of the Netherlands, we have to refer to Article 94 of the Dutch Constitution, which says that Dutch law is not applicable if such application is in conflict with provisions of treaties or decisions by international organizations binding on all persons. So the supremacy clause refers to the same limited set of international provisions as the clause on the invocability or direct effect does. But those two provisions, 93 and 94, they don't make very clear how to distinguish those provisions that have direct effect from other provisions of international law. So this was left to the courts. And there are two important cases that I wanted to discuss with you. The first case is a case between the National Railways and the Trade Union Confederation. And this was about the right to strike, basically. So the unions had motivated their workers to go on strike, and the National Railways wanted the judge to prohibit the unions from doing so. But the Trade Union Confederation relied on or invoked Article 6, Paragraph 4 of the European Social Charter, which included, in their view, a right to strike. And so they directly applied this provision before the Dutch courts. So the question was, can you do this? Can you directly invoke this provision before Dutch courts? And then the Dutch Supreme Court said this was possible, provided three conditions were met. First, Article 6.4 has direct effect, can be directly invoked, if we cannot infer from the travaux préparatoires that direct effect of this provision was excluded. Second, the provision does not oblige the Dutch legislator to make domestic law with a particular content. And third, the provision is suitable by virtue of its content to be applied as if it were a provision of domestic law. So these three conditions have to be met. And in the case, these three conditions were indeed met. So the Trade Union Confederation could invoke Article 6, Paragraph 4 of the European Social Charter, and they could go on strike. It is important to note that direct application or invocability of an international provision should not lead to a situation in which a judge is basically asked to make policy. So to fill in the discretion left by the international provision to the lawmaker of each and every state. But Article 6.4 was so clear, it basically obliged or called upon all states to recognize the right to strike. So there was no policy discretion that need to be filled in. And so the Trade Union Federation could directly rely on it, and they could go on strike. So let's now fast forward a few years and have a look at another decision by the Dutch Supreme Court, a very recent decision about the smoking ban in public places. So the Tobacco Framework Convention, Article 8, Paragraph 2, obliged all states party to the treaty basically to ban smoking from public spaces. The Netherlands had implemented this treaty, this obligation, but had made an exception for small cafes without staff. So small cafes that were run basically by the owner. It was considered that in those places smoking should still be allowed. So the question was whether this exception to the general smoking ban was consistent with Article 8, Paragraph 2 of the Tobacco Framework Convention. And a society of non-smokers then went to the judge and alleged that the Netherlands had breached this obligation. So again, this society directly invoked an international provision, this time Article 8, Paragraph 2 of the Tobacco Framework Convention, before the Dutch judge. So a question of direct effect, invocability. And interestingly, the court did not exactly apply the same criteria that it had developed in the 1986 case of the railway strike. So in 2014, it was the Dutch Supreme Court's view that Article 8.2 had direct effect, despite the fact that it called upon the Dutch legislator to make domestic law with a particular content. But the provision was suitable by virtue of its content to be applied as if it were a provision of domestic law. It was sufficiently clear and precise in the results that needed to be achieved. So let me show you the provision. So the provision, Article 8, Paragraph 2, it called upon the Dutch legislator to make law. But the purpose of this law was so clear, it was to put in place a complete smoking ban, that it left very little discretionary power to the legislator. So there was very little policy to be made, and thus the provision was suitable, it was clear and precise enough to be applied and to be invoked directly before the Dutch courts. And so these small cafes with their smokers, we will see no more of them after the judgment was rendered in 2014. Thank you for your attention.